thank you for that introduction. I'm joining you all from Johannesburg, South Africa, and it's really a privilege to be part of the conference, the ICC Kenya conference. So I have my discussion essentially in 10 minutes, and hopefully I will be able to do it justice, is talking about the AFCFTA. And I think all of us being Africans would know about the African Continental Free Trade Agreement by now, but also then the role of ADR and where it fits as part of the African Continental Free Trade Area and the establishing agreements and protocols underlying that. When we talk about AFCFTA, it's one of the most laudable objectives of the African Union and the African Union member states. And if you look at the history from where it started, so the agreement was signed in March 2018 by 44 of the 55 African states. To date, we have the last state that has ratified the AFCFTA or establishing agreement was Tanzania, and that was actually last week, and the week before that it was Burundi. So if you look at it from a East Africa community perspective, there's probably most of the East African states have ratified the AFCFTA, which is fantastic, because when we talk about the AFCFTA, the laudable objectives of that is ultimately to ensure that African businesses are able to tap into a much bigger market of 1.3 billion people and increasing. So that's a massive market for trade in goods and services. And obviously also when you have trade in goods and services, you have also the potential for investment, establishing manufacturing plants in various jurisdictions on the continent to make sure that African businesses can service the entire African continent, because ultimately the benefits of reduced tariffs, preferences, trade facilitation, and access to a number of other markets. So you have a market, as I mentioned, of almost 1.3 billion people with a combined GDP of $3.4 trillion and increasing. So it's a massive market. And when we talk about that, the ultimate consequence of having a trade agreement of this significance is that there will be disputes. And disputes are recognized as part of the AFCFTA protocol, to say that central to the effective application of the AFCFTA, you need to have an effective dispute settlement process. And coincidentally, for those that have read through the protocols, including the protocols on the, and just go to the next slide, the protocol on the rules and procedures for the settlement of disputes, there is actually a large portion of the protocol on the settlement of disputes deals with the settlement of disputes on an amicable basis. So there is an encouragement that states that are members of the AFCFTA resolve their disputes on an amicable basis. The African way, where there is consultation, where there's either a initiation of a good office through a third-party state, or conciliation and mediation. So the AFCFTA dispute resolution protocol emphasizes the resolution of disputes by means of an amicable basis. It also sets out various principles that we would also find in domestic law, like settling when a complaining state initiates a dispute, and that dispute obviously would have been triggered by a national of a particular state, say Botswana feels aggrieved by the DRC, where that national has not gotten those particular benefits in the DRC that flows from the AFCFTA, its protocol and annexes. And then there's a complaining state against, which is say Botswana, against the DRC. On that basis, the states should try and attempt to resolve the matter on a amicable basis through consultation. As consultation contemplates, you can do it on a without prejudice basis, have frank discussions, ensuring that ultimately what is achieved is not an antagonistic system, for the resolution of a dispute on the application or interpretation of particular provisions of the AFCFTA and the protocols and annexes, but to have discussions among states to try and resolve it. If that doesn't work, then you can have an independent third-party mediator or conciliator to try and resolve the issues between the states. Now, as you would see, the dispute settlement mechanism currently contemplated is mostly in relation to states. So any investor or trader that utilizes the benefits, because that's ultimately the purpose of the AFCFTA. It's not for the states to utilize it, but for private sector parties that are active in the economy to utilize the preferences and benefits for the benefit of African businesses and ultimately for all Africans to benefit from the integrated economic project. Now, what is lacking and what is still being negotiated, you would see from the agreement establishing the AFCFTA, the darker blue colors, the protocol on competition policy, the protocol on investment, and the protocol on intellectual property. And I think there's also discussions on the protocol on e-commerce. That's still part of phase 2. So that's being negotiated. Under the protocol on investment, what we think would happen with reference to what is currently in a number of investment protocols on a more multilateral level in different regions, economic blocks on the continent is, if you look at the Pan-African Investment Code, it would be the contemplation is that investors would most probably also have access to resolve disputes with states where there's an investment dispute. And the contemplation also appears to be that mediation will be encouraged or conciliation. So resolving disputes with African member states. So this is now an investor from, say, Namibia who has an issue with the South African government in terms of how they treated the mining consortium. That investor, that African investor would be entitled to utilize the mediation process to try and resolve the dispute. And there's also contemplation of potentially a multilateral investment court from an African perspective. But all of these are still, so the process in negotiating the investment protocol, a lot of the stuff are not really in the public domain, and the documents that most of us as lawyers who are active in the sector and field is you need to rely on what governments are doing and what is the attitude of governments, as also highlighted in like the Pan-African Investment Code, which is a draft document that highlights where governments are going. So it's mediation, arbitrations from an African perspective, arbitrations have had its fair share of criticisms. But I think there's still a big role for arbitration in investor-state dispute settlement on the African continent, subject to what happens also with this multilateral investment court system that's being proposed. Similarly, on a state-to-state basis, there's also the option for arbitration. So if parties do not want to utilize the panels, which is just created under this dispute settlement body to resolve a particular dispute, you can agree to arbitrate the dispute, and the value of an arbitration award would be similar to the recommendation or decision of the dispute settlement body, which ratifies the panel report. So that's essentially, in that 8 minutes, I tried to summarize what is the AFCFTA, what is the benefits from a dispute resolution perspective, what is contemplated from an ADR perspective. So there is a lot of features that encourages ADR among states, and hopefully when we see the investment protocol, it will also encourage in ADR from an investor or trader and a state perspective. But if you have any questions, please feel free to reach out. The organizers also have our details. So hopefully Mercy, I've done it within 10 minutes.